Good evening, officers. This is Amrinder Singh Shergill, Additional District and Sessions Judge from the state of Punjab, on deputation with Chandigarh Judicial Academy as a faculty member. Sorry, we are meeting today evening at this time, which will also continue for the coming 2 days, tomorrow and day after. This is necessitated on account of an order passed by the Honorable Supreme Court on 14th September 2022. The case in which the said order was passed, as you all are aware, is suo motu writ petition criminal number 4 of 2021, wherein the Honorable Supreme Court was dealing with a matter of policy strategy for grant of bail. We all are well sensitized that the end and the ultimate objective of administration of justice is to restore, to achieve the peace in the society which got disturbed on account of commission of some wrong, some offense, some crime by somebody, wherein some other person gets offended, aggrieved, etc. So the Honorable Supreme Court has also time and again guided us as to how we can reduce the pendency of the cases before us. The Honorable Supreme Court has taken the assistance as amicus curiae from Mr. Gaurav Agrawal, Mr. Liz Matthew, and Mr. Devansh A. Mohta. The discussions were also held with the Mr. K.M. Nataraj, ASG, representing the Government of India. This committee came out with certain suggestions which the Honorable Supreme Court has directed us to observe and to obey. These suggestions are regarding the different aspects of disposal of criminal cases by resorting to the triple method of plea bargaining, compounding of offences, and releasing the offenders on probation under the Probation of Offenders Act 1958. On the first day, I'll be taking this brief session on the subject of compounding of offences, and in coming days, the rest of the two topics will be covered. The Honorable Supreme Court in the said order has suggested for organizing brief training sessions on the said subjects by the academies for the benefit of all the learned judicial officers. I have understood the said suggestions, now the directions, and have segregated them in 3 steps. During this session, I'll be touching upon the various steps which the Honorable Supreme Court has directed us to take. Number 1. Number 2, the statutory provisions contained in section 320 of the Code of Criminal Procedure, and lastly, few important judgments which are handy in disposal of criminal cases through compounding. I have a humble request that I am a humble student, just initiating a discussion. During the course of this session, if any of the learned officer has anything to ask, he or she is most welcome. All he is required to publish his question through the chat available on the system. Otherwise, I'm just a message away. All of you have my number. As and when any issue arises on the subject, I'll be happy to answer your queries. Now, coming to the first aspect of the session, the steps which we are required to take. The number one step, as per the Honorable Supreme Court, is the identification of cases. We all know that all offences are not compoundable. Only those offences which are detailed in the two tables, the next after subsection 1 and subsection 2 of section 320 of the code, that those offences can be compounded. The rest of the offences which do not find any mention in the said table are non-compoundable. So first step in identifying the cases is only compoundable offense cases are to be identified. As we all know, if one of the section is non-compoundable, the whole case becomes non-compoundable. So we are not to identify the accused or the offenders, but we are to identify the cases in which the accused is charged with different sections and all of them are compoundable under law. Hereafter, the public prosecutor is directed to assist the court after ascertaining the criminal antecedents of the accused as to whether such an accused is the first time offender or is a habitual offender. So in identification of cases, we have to identify cases of those accused who are first time offenders and the offences with which they are charged are compoundable under law. The second step is procuring the presence of the stakeholders by issuing a notice of their appearance on any suitable day which the court thinks fit. The notice is to be issued to both the stakeholders, accused on the one side and the person with whom the offence may be compounded on the other side. The said notice is required to indicate the intention of the court that it proposes to dispose of the case by considering the said three methods, including the compounding of offence under section 320 CRPC. Furthermore, the said notice is also required to indicate that both the stakeholders, the accused, as well as the person with whom the offence is to be compounded, are entitled for free legal aid. And the further notice is that both the stakeholders, the accused and the person with whom the offence is to be compounded, to remain present before the court on the said date, and further they may obtain the assistance of their advocates if they so desire. Once the parties come present on the date so notified, the suitable day so fixed by the court, the third step is to persuade the parties, and in case the party seeks time for thinking over the matter, to give them time by adjourning the matter for further date. And through these steps, we have to dispose of the criminal cases pending before us, which are compoundable in nature. The Honorable Supreme Court earlier also, in a matter inhuman conditions in 1382 prisons, cited in the Supreme Court cases as 2016 3 SSC 700, has already directed the secretaries of the district legal committees to look into the issue of release of the under trial prisoners in compoundable offences by effectively exploring the possibility of compounding rather than adjudicating the matters on trial. Now coming on to the second aspect of this session, as to the substantive provision, the statutory provision, section 320 of the Code of Criminal Procedure, providing the compounding of offence. It is split up in many subsections. The subsection 1 says the offences punishable under the sections of the IPC specified in the first two columns of the table annexed with this subsection may be compounded by the persons mentioned in the third column of that table. So only those persons who are mentioned in the third column of that table may compound the offence with the accused. These persons, if we look at them, are either the complainant, who is an injured, or a victim. So before compounding the offence, the presence of such a person is necessary before the court, and court has to satisfy that the person who is compounding the offence with the accused is not under any pressure, threat, or coercion, etc. Then comes subsection 2. Subsection 2 talks about those offences to compound which the permission of the court is required. So there are different offences than the offences provided in the table after subsection 1. There are two tables in section 320. First is after subsection 1 and the second is after subsection 2, wherein the permission of the court is required before a person mentioned in the third column of the table compound the offence with the offender. Subsection 3 talks about three different scenarios wherein, besides the offence which is compoundable, the abetment of such offence, the attempt to commit such offence is also charged besides the sections of vicarious liability under section 34 or section 149 of the Indian Penal Code. Joint liability. The subsection 3 says if an offence is compoundable under the section, abetment of such offence, and attempt to commit such offence, accused charged under section 34 or 149 of the IPC, these situations may also be compounded in the like manner. So there is no inhibition in compounding an offence wherein the charge is read with section 34 or is read with section 149 of the IPC, besides the abatement of such offence or an attempt to commit such an offence. Thereafter is subsection 4. It also talks about three situations. First situation is the person who is competent to compound the offence, having mentioned in column number 3 of the table, is under age, is less than 18 years of age, is a minor, or is under some mental disability, is an idiot or a lunatic. What will happen in such cases? The provision says, in such cases, any person who is competent to enter into a contract on their behalf can compound such offence. The only requirement is the permission of the court will become necessary. That means a person of underage, an idiot or a lunatic can also compound the offence through a person competent to enter into a contract on their behalf with the permission of the court. Thereafter is the remaining scenario, clause B, that the person who is competent to compound the offence is dead, is no more. What will happen in that scenario? The provision has guided us that in that case, the legal representative will be competent to compound such offence. Only requirement is the consent of the court will be required. That means the legal representative of a dead person competent to compound the offence can compound the offence with the consent of the court. Thereafter is subsection 5. It talks about the scenario when the accused has already been committed for trial or has already been convicted and the appeal is pending before the Honorable Appellate Court. Then this provision provides no compounding, no composition of the offence shall be allowed without the leave of the court. Leave of the court in which the offence stands committed, the appeal is pending adjudication. So in such a scenario, the leave of that superior court, that appellate court is must at the stage of compounding the offence besides the other legal requirements. Thereafter is subsection 6. It says the Honorable High Court, the Honorable Court of Session, while exercising the powers under revision, can also compound an offence with the person who is competent to compound the offence under this section with the accused. So these powers are with all the courts at all the stages, provided compounding takes place with the concerned person mentioned in column number 3 of the tables annexed in section 320 of the code. Thereafter comes subsection 7. It talks about the scenario which the Honorable Supreme Court has already directed, that in case of a previous conviction liable to enhanced punishment or a different nature of punishment, such an offence cannot be compounded under the provisions of this code. So always be vigilant while compounding the offences. Take the report of the public prosecutor, take his assistance as far as the previous criminal incidents of the offenders is concerned. Thereafter is subsection 8. It says the compounding of the offence shall result in acquittal of the accused, not the discharge. So as and when we are compounding the offences, we have to acquit the accused from the offence which he has been charged with, not the discharge of the accused. Lastly, but not the least, is subsection 9, which says no offence shall be compounded except as provided by this section. That means an offence which do not find place in the said two tables cannot be compounded by any level of the code. Now, coming on to certain judgments which are handy in throwing some light on the aspect of compounding. As we all know, just discussed under section 320, subsection 9, a non-compoundable offence cannot be compounded by the trial courts, by our courts. But the Honorable Supreme Court, exercising its jurisdiction under Article 142 of the Constitution of India, can compound even a non-compoundable offence. The citation, if you would like to notice, Guhan versus State, represented by Inspector of Police 2022 10 SCC 542. I repeat the citation, Guhan versus State, represented by Inspector of Police 2022 10 SCC 542. In the said case, the conviction was under section 307, read with section 149, invoking the powers under Article 142 of the Constitution of India. The Honorable Supreme Court permitted the parties to compound the offence and modify the sentence to the period already undergone by them. Similarly, another citation is Uni Krishnan alias Uni Kuttan versus State of Kerala 2018 15 SCC 343. I repeat the citation, Uni Krishnan alias Uni Kuttan versus State of Kerala 2018 15 SCC 343, wherein the Honorable Supreme Court, invoking the powers under Article 142 of the Constitution of India, has compounded an offence punishable under Section 394 of the Indian Penal Code. Now coming on to the other aspect wherein the leave of the court is required, as to what is the guiding factor which is to be considered by the court at the time of grant of the leave or refusal of the grant of leave at the time of compounding of such an offence. The citation, please note down. The case is Pravat Chandra Mohanty versus State of Odisha 2021 3 SCC 529. I repeat the citation. Pravat PRAVAT V for victory Chandra Mohanty versus the State of Odisha 2021 3 SCC 529, wherein the guiding factors told to us by the Honorable Supreme Court are the nature of the offence with which the accused is charged and its effect on the society. The Honorable Supreme Court says, please consider these two aspects while granting permission, while granting leave to compound the offence, the nature of the offence and its effect on the society. Another judgment is Bhagwan Das versus the State of Uttarakhand 2019 4 SCC 354. I repeat the citation, Bhagwan Das versus the State of Uttarakhand 2019 4 SCC 354. The Honorable Supreme Court has said, merely because an offence is compoundable under Section 320 CRPC, it does not mean that we are bound to give the permission. The Honorable Supreme Court has said the discretion is to be exercised by keeping in view the nature of the offense committed by the accused. Here, the guiding factor is the nature of offense. Thereafter, another aspect on which the judgments are there is a compromise has taken place, a settlement has taken place, a peace has come in the rival parties, but the offense is non-compounding. The first and the foremost remedy there is to invoke the powers of the Honorable High Court under Section 482 of the Code in getting quashing of the matter. The courts cannot compound a non-compoundable offense. The Honorable Supreme Court in Murli versus State, represented by its Inspector of Police, 2021, 1 SCC 726. I repeat the citation. Murli versus State, represented by its Inspector of Police, 2021, 1 SCC 726, has provided us that in non-compoundable offense, the fact of amicable settlement of the dispute can be a relevant factor for the purpose of reduction in the quantum of sentence. So you can always take note of the fact that the parties have amicably settled the matter is non-compoundable. We can always consider this thing at the time of the quantum of sentence. The matter before the Honorable Supreme Court was Section 307 IPC besides Section 324 of the IPC. Please note another case on the same aspect, Manjeet Singh versus the State of Punjab, 2020-18 SCC 777. Manjeet Singh versus State of Punjab, 2020-18 SCC 777. The Honorable Supreme Court says, where we cannot compound the offense, certainly we can consider at the stage of quantum of sentence, at the stage of awarding the quantum of sentence. Thereafter, there is another aspect, which is there are more than one accused. With one accused, the offense is compounded. What about the remaining accused? Whether the case is to be compounded or whether it is to be compounded with an accused. The Honorable Supreme Court in Malana versus State of Karnataka, 2019-14 SSC 640. I again repeat, Malana versus State of Karnataka, 2019-14 SCC 640. In the offense charged under Section 354 and 448 IPC, compounded the offense with one of the accused and convicted the remaining three accused for different punishments. Thereafter, another scenario is if an offense is compoundable, but thereafter an amendment takes place and that offense becomes non-compoundable, what is to be seen? On such a scenario, please note down one of the judgment, Shankar Yadav versus State of Chhattisgarh, 2018-13 SCC 452. I repeat, Shankar Yadav versus State of Chhattisgarh, 2018-13 SSC 452. The offense involved was Section 324 IPC. We all know through the Criminal Law Amendment Act 2005, which has come in force with effect from 23rd June 2006, Section 324 IPC has become non-compoundable. before 23rd June 2006, the offence was compoundable. So in the said case, the Honorable Supreme Court has said the date on which the offence has occurred is to be seen. If that date is before 26th June 2006, the offence will remain compoundable. If the date is after the said date, then the offence will remain uncompoundable. Thereafter is the another aspect wherein the Honorable Supreme Court has given us certain guidelines as to the imposition of costs at the time of compounding an offence under Section 138 of the Negotiable Instruments Act to achieve a policy that compounding should take place at the earliest. More delay, more is the cost which is to be imposed. So the Honorable Supreme Court has passed certain guidelines in the case Damodar S. Prabhu versus Sayyid Babalal H. 2010 5 SCC 663. I repeat the citation. Damodar S. Prabhu versus Sayyid Babalal H. 2010 5 SSC 663. The Honorable Supreme Court has said that if the compounding do not take place at the first date or the second date, at the application for compounding the offence comes at a subsequent stage, then while allowing the compounding, keeping in view the other parameters, the accused is required to be imposed with a cost of 10% of the check amount to be deposited in the account of the Legal Services Authority. The Honorable Supreme Court has further guided us that if the application for compounding is not made before the magistrate court, but is made before the sessions court or the high court in a revision or appeal, such compounding may be allowed on the condition that accused pays 15% of the check amount by way of cost in the legal services. The Honorable Supreme Court has further guided that if the accused becomes late and the application for the first time for seeking the compounding is made before the Honorable Supreme Court, then the figure increases to 20% of the check amount. The Honorable Supreme Court has clarified that such costs are to be deposited in the Legal Services Authority's account of the respective court. That means if the Honorable Supreme Court is compounding, then the Legal Services Authority institution at the level of Honorable Supreme Court, if the High Court, then the Honorable High Court, if the Sessions Court, then the District Legal Services Authority. The Honorable Supreme Court has further sensitized us in the said judgment only that the imposition of the said cost, which the Honorable Supreme Court has guided, is a matter of discretion. There is no compulsion. The scales of the said costs have been suggested so that there remains uniformity throughout all the courts in our country. The Honorable Supreme Court has mentioned that the competent court can, of course, reduce the cost with regard to specific facts and circumstances of the case, but he has to record the reasons for his such variance. So that does not mean that if the scale has been provided by the court and the matter is such where the person is not able to pay the said 20%, the said 15%, or the said 10%, the compounding cannot take place. The Honorable Court can always consider the special facts and circumstances of the said case and can therefore vary the said cost, therefore can reduce the said cost. It got further clarified in another judgment by the Honorable Supreme Court. The case is MP State Legal Service Authority versus Pratik Jain 2014-10 SCC 690. I repeat the citation. MP State Legal Service Authority versus Pratik Jain 2014-10 SCC 690, wherein the Honorable Supreme Court has held that the said parameters are also applicable if the matter is compounded before the Honorable Lok Adalat. The said practice cannot be dispensed with if the compounding takes place in the Lok Adalat. Lok Adalat and the other courts are at the same footing. There is no difference in the same. Only thing is, if there are special reasons, there are specific reasons in the facts and circumstances of the case, the court can always exercise its discretion and can always reduce the cost. The only thing is that there should be special reasons, special facts, special circumstances which requires the reduction of the cost, interference in the set scale. This is the brief session outlining the general aspects about the compounding of the offense to reduce the pendency of the criminal cases which are compoundable in nature. Instead of adjudicating them, instead of deciding them on merits, we should always encourage parties to compound the offense, to settle the matter, to bring peace in them, in the society, in their house, in their locality. I am not being able to see any question. Is there anybody who intends to ask any question or to throw any light in the discussion? Okay, thank you so much. You can always WhatsApp me. You can always message me. I'm in your service. I'm duty bound to answer you, to respond to you. Thank you so much for patiently hearing me. Thank you so much. Have a good day. Thank you.